The Boston Globe started breaking the headlines yesterday that a woman charged in Massachusetts with criminal contempt of court is in fact a grand juror from the Karen Read case and was leaking information related to the Karen Read case. That is what the media headlines are running with. They say they have confirmed it through multiple sources. They have not cited those sources. They have not named those sources. They do not have to, but that is what they have said. My cautions are, 1, grand jurors who sit on federal grand juries. And remember, in the Karen Read case, there were 2 grand juries. There was a state grand jury that charged her in June of 2022 when her charges were enhanced. And then there was a federal grand jury. The federal grand jury, from all of our understanding, was not looking into charging Karen Read. That makes sense to me. A federal grand jury would not be looking into charging Karen Read with the death of John O'Keefe. That's not what a federal grand jury really would be looking at. We have heard that the grand jury was looking into the investigation of the Karen Read case. This is the federal grand jury where we heard from numerous witnesses in the trial that they testified at that proceeding. Jen McCabe, Carrie Roberts, ARCA. That's where ARCA came from. The defense says they didn't even know about ARCA until they got all the discovery from the feds, because the feds dumped thousands of documents on the prosecution and the defense. And the defense was like, we found gold at the end of the rainbow. This never happens because of this case. So the federal grand jury, it seems to me, was looking into things surrounding the Karen Read case and investigation. Local prosecutors are not part of a federal grand jury. The defense is not part of any grand jury. The feds do not bring anybody else into a grand jury. It is the grand jurors and the prosecutors. So the U.S. attorneys. Generally, especially on federal grand juries, you will sit for either a couple days a month, 1 day a week, but you will come in periodically and sit on numerous cases over the span of either 6 months to a year. And so it's not just one case that grand jurors will hear. So there is always caution when we were talking about a grand juror leaking information in a case to know exactly which case. And we're going to have to take all that information that we have and see what we can sort. I've got the court documents. I've got the media reports. I've got a law degree. I have thoughts. Massachusetts woman charged with leaking grand jury information. That we know. Boston, a DOCKET. Massachusetts woman has been charged with allegedly disclosing information presented to a federal grand jury to unauthorized individuals. This says allegedly. That is part of the press release. We have a plea signed. A plea has not been entered yet, but we have a plea signed on the record. So they have already agreed to plead guilty to this. They have not changed that plea in court. The U.S. Attorney's Office is actually really good at this. They are very clear about alleging what's going on until there is a change of plea. They do a very good job with that. So that's why alleged is going to be in all of this. Jessica Leslie, 34, was charged Friday, July 11th with 1 count of criminal contempt. So if you're like, how did the media know about this? Well, the U.S. Attorney's Office did make a press release yesterday. And I would imagine that most media outlets in Massachusetts get alerts when stuff goes out from the U.S. Attorney's Office or get these emailed to them directly from the U.S. Attorney's Office when there's a press release. Charged Friday, July 11th, 1 count of criminal contempt. Defendant has agreed to plead guilty and will make an initial appearance in federal court in Boston at a later date. That later date's July 22nd. It's already on the docket. A plea hearing has not yet been scheduled by the court. That could also happen on July 22nd. I keep saying might happen or could happen on July 22nd because it's an initial hearing and the court could say, come back in a week. I doubt it because it's already signed and taking a plea doesn't take that long, but we'll see. So the initial appearance is going to be July 22nd. According to the charging documents, on various dates between August 11th and March 4th, the defendant disclosed sealed information to unauthorized individuals, including the names of various witnesses appearing before the federal grand jury. That's a huge no-no. The substance of witness testimony and other evidence presented to the grand jury in violation of the federal rules and court order. So this is a violation of the court order and the federal rules, which is why it's a criminal contempt charge. The criminal charge of contempt provides for a sentence of any term of years in prison, 5 years of supervised release, and a fine of up to $250,000. I really think you should fine people. I mean, going to jail is maybe a lot. I think people should have to pay. We're going to talk about what the plea is for. That's not what the plea is for. That is the maximum possible sentence. Sentences are imposed by a federal district judge based upon the U.S. sentencing guidelines and statutes, which govern the determination of a sentence in criminal cases. United States Attorney Leah Foley and Ted Docks from the FBI made the announcement today. Assistant U.S. Attorney Ann Prudy, the chief of the Major Crimes Unit, is prosecuting the case. You do not want the chief of the Major Crimes Unit on your ass. The details contained in the charging documents are allegations. The defendant is presumed innocent unless and until proven guilty beyond a reasonable doubt in a court of law. Well, they're going to plea. So it's giving guilty vibes because they've already signed a plea deal saying that they're going to plead guilty. They just haven't done it yet. This is the plea agreement. This was filed July 15th, yesterday, Tuesday. Note that this letter is dated July 11th. Why does that matter? Because the charging document and the plea document are from the same date. That only happens when there have been conversations beforehand. That does not happen by accident. That does not happen by chance. That happens when these conversations happened beforehand. To the attorney, for the individual, this also means that someone who was on the grand jury, who got a jury summons just like y'all do if you're in the US, already has a lawyer. So the feds had already engaged with this individual enough that by the day they were charged, they already had a criminal attorney. The United States Attorney for the District of Massachusetts and your client agree as follows. Change of plea. As soon as practicable, the defendant will waive indictment and plead guilty. So they're not going to do a preliminary hearing. They're not going to do a grand jury. They're going to waive their indictment and just plea. To count one of the information, criminal contempt, in violation of 18 U.S.C. 401 sub 3. Defendant admits that defendant committed the crime specified in this count and is in fact guilty of it. Penalties. This is not the plea deal. This is advisement of potential penalties. This is the maximum. You have to be advised of the maximum. Defendant faces the following penalties: incarceration for any term of years, which is wild that the judge can just pick, well, under the federal sentencing guidelines. Supervised release for up to 5 years. 5 years on probation is a really long time. A fine of $250,000, well, up to, unless incarceration is imposed, and a mandatory special assessment of $100. Rule 11C1C plea. In accordance with Rule 11C1C, if the court accepts the plea agreement, the court must include the agreed upon disposition in the judgment, meaning the judge can't take the plea and then sentence to whatever. This is a Rule 11 plea. Rule 11 means the judge agrees that the sentence will be what the plea agreement is. In some cases, especially in federal cases, less depending on the state, the defendant will plea and the court will decide. And the government will make a recommendation and say, Your Honor, we think it's this. And the court can say, I think it's more, I think it's less. I don't have to do what you say. This is a Rule 11 plea. The judge doesn't do what they want. The judge says, if I accept the plea, I'm accepting the plea deal. And if the court doesn't accept the plea deal, then this plea doesn't get taken. The court's not going to do that in this case, unless the court asks for more of a fine. It's possible. If the court rejects any part of this plea agreement, the U.S. attorney may void the agreement, or the defendant may withdraw from it. Defendant may not withdraw a defendant's plea for any other reason. So if the court says, I'm going to fine you a fuck ton of money, the defendant can go, yeah, I didn't agree to that. I'm not doing that. But the defendant can't just change their mind. Only if the court changes the deal. Should the U.S. attorney void the agreement or the defendant moves to withdraw the defendant's plea, defendant agrees to waive any defenses based on statute of limitations, constitutional protection against pre-indictment delay, speedy trial. Likely not a problem here, but continuing. Sentencing guidelines. Remember, the feds have a whole flowchart of how this works. The parties agree based on the following calculation. Defendant's total offense level under the guidelines is 10. Defendant's base level is 14. Defendant's offense level is decreased by 2 because defendant has accepted responsibility. Defendant's offense level is decreased by 2 because defendant is a 0-point offender, meaning no prior record. Base level 14 minus 2 to get us to 10. Defendant understands that the court is not required to follow this calculation. Defendant also understands that the government will object to any reduction in defendant's sentence. I mean, there's nowhere to reduce it to. like at all. Reduction in defendant's sentence based upon acceptance of responsibility and may be released from the parties' agreed upon disposition in paragraph 5 if A, at sentencing, defendant directly or through counsel indicates the defendant does not fully accept responsibility for having engaged in the conduct underlying each of the elements of the crime to which defendant is pleading guilty, or at the time of sentencing, defendant has committed a new federal or state offense or has in any way obstructed justice. So if you're like, does the defendant have to cooperate? Yeah, they have to cooperate and likely already have. Nothing in this plea agreement affects the U.S. Attorney's obligation to provide the court and the U.S. Probation Office with accurate and complete information regarding the case. Agreed disposition. This is the plea. The other parts were advisements. This is the plea. The parties agree on the following. Incarceration for 1 day deemed served. No fine. 24 months of supervised release. Probation. The probation is going to be cooperate with law enforcement, stay out of trouble. Do you know what cooperate with law enforcement means? Provide us the information that we are asking for, which has probably already been done. If we're like, hey, you need to come testify, do it. A mandatory special assessment, they can't waive that, of $100, which the defendant must pay to the clerk of court on the date of sentencing. What will likely happen here is that when the case goes forward on July 22nd, if the court agrees, the change of plea will be entered. It will be put over for 4 months plus minus for a PSR to be done, and then sentencing and probation will start. We're going to read the acknowledgement of plea. Signed. I have read this letter and discussed it with my attorney. This letter accurately presents my agreement with the United States Attorney's Office for the District of Massachusetts. There are no unwritten agreements between me and the United States Attorney's Office, and no United States government official has made any unwritten promises or representations to me in connection with my guilty plea. I have received no prior offers to resolve this case. I understand the crime I am pleading guilty to and the maximum penalties for that crime. I have discussed the sentencing guidelines with my lawyer, and I understand the sentencing ranges that apply. I am satisfied with my legal representation my lawyer has given me, and we have had enough time to meet and discuss my case. Does this sound familiar? Yes, it's standard. I'm entering into this agreement freely and voluntarily because I am in fact guilty of the offense. I believe this agreement is in my best interest. It's a good agreement. Signed, dated July 14th, 2025. The media is saying that this is connected to Karen Read's case. And with the timing of these charges, not when they're brought, but the time span, it covers the time span that Karen Read's case was before the federal grand jury. It also covers the time span that other cases were before the federal grand jury. What we know for sure is that the defendant is from Massachusetts, sat on a federal grand jury. Grand juries cover numerous cases, not just one. They were advised that grand jury proceedings are secret and sealed, and that they are not to disclose that information to anyone. Between August 11th, 2022 and March 4th, 2024, on numerous occasions, this individual disclosed the names of witnesses, the substance of their testimony, and other evidence that was disclosed to a grand jury, to individuals, so more than one person. The feds found out about it. They charged them with criminal contempt, contemporaneously offered a plea deal. That means that there were ongoing conversations before this was charged. This didn't come out of the blue for this individual. They probably got a target letter, and they were probably asked to cooperate. Do we know that? No. It's likely that they gave more information to the feds. It's likely that they cooperated with cell phone dump, email dump, etc. So from there, I think the only way we will see this coming up is if the information released never became public and it impacts a third party and they sue over it. It is my suspicion that this was likely tipped off by either communications. It's possible that social media made them look more deeply into it. We know the feds monitor all things on social media, but it's possible that communications that were dumped are what did this. Would I be surprised if this was regarding multiple cases? Not at all. Because if one person's sitting on a grand jury and spilling the tea on something, I wouldn't be surprised if they're spilling the tea on more than one thing. There are plenty of ways that the feds dump people's phones and then stumble into stuff that they didn't know. It is just as likely that this was found coincidental to something else as it is that this was found because of social media. And I'm not going to give one more weight over the other. The media 100% is running down the path of this is the Karen Read case. It's possible. It's possible that it's not. And it's possible that it's this and. So those are my cautions. What does that mean for Karen Read? Well, not much. Unless the information was going to Karen Read, I guess. Even then, what would Karen Read do with that information? And having that information is not the problem. Telling that information is the problem. So who else could have gotten this information? Well, anyone. People pretending to have information they don't have is not uncommon on social media, which is why I kind of wait until we see multiple reports on it. And once we had ABC and Boston Globe reporting on this, that both claim independent sources, could those sources be the same one? Yes. The sources could 100% be the same source. We will continue to see. Does this impact the Karen Read case in any way? It could, but not in the outcome to Karen Read. If this information was going to like friends and family, it's one thing. If this information was going to anyone who had a duty to the court, that could be another thing. Because generally, having the information is not the issue. Being told the thing's not the problem, unless you have a duty to report that. Telling the thing is what is forestalled by court order. Could we see more from this? Could we not see more from this? Maybe. I'm curious to see where this goes. This will be in court the 22nd. I think there will be a change of plea that day. I don't know if we will see anyone else making statements about this who are involved in the state level Karen Read case. I'll be interested if they do, and I will keep an eye for it because it's really hard to know from sources who sources are. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.